Good afternoon. My name is Alina Shevtsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking video, I would like to talk to you about special immigrant juvenile status and main issues that may arise when one is trying to obtain a status. So, to get a special immigrant juvenile status, first of all, a person has to be under 18 or under 21, depending on the state where they reside. And the first step in obtaining the status would be to go to the family court in the state where the person resides, in the county where they reside, and request a finding. First of all, the person has to be found to have a guardian, and then the person requests special findings order from the judge, where the judge will determine that the person is unmarried, under 21, the person is dependent on juvenile court, and some other findings. But the main challenge I see when people are trying to go to family court is not even the findings, it's not the paperwork itself, because the paperwork itself, the clerks will help you if you're pro se, or if you have a lawyer, of course the lawyer will do the paperwork. It's basically clerical work. The main challenge I see is that people have hard time serving their parents. Serving their parents, because in family court the proceedings were designed for state proceedings. They were not, I believe, they were not designed globally for international situations. And for the most part, the guardianship proceedings are done under state local rules, and they require that the respondents in the proceedings, which are parents of the minor, be served with the paperwork. And this is hard. Why? Because the person is overseas. Or at times, usually kids will not know where the parent is at all. Very often, a typical SIJ person would be somebody who who's one parent, let's say, in the United States, and another parent, even though father, for example, listed on the birth certificate, has not participated in the minor's life at all. But now you either have to find that person or request a waiver from the court, a waiver of service. So what do you do when you need to serve the papers? Well, first of all, the first option, obvious, if you know where the parent is, you're trying to serve them. If they're more or less cooperative, or they're not interested in you at all, not demanding money from you for signing papers and things like that, then you can ask them to execute a waiver of service of process. Is different from a motion to waive the process. A waiver basically states that the parent is not interested in participating in the proceedings and designates a proposed guardian to receive all the paperwork of the county. If this is not an option because you really do not know where that person is who is listed on your birth certificate, then you would ask the court for the to waive the service completely. The motion has to be made. The problem is that all the steps, they require time, and if you're aging out, you have to act fast, because in some counties in New York, the court will adjourn the case and adjourn the case and adjourn the case, and the case will be pending for too long, and you risk aging out. So another major challenge in obtaining a SIJ status is when the case is already filed with USCIS, and USCIS states that you filed the case just for the purposes of obtaining an immigration benefit, for the sole purposes of obtaining immigration benefit. And if you file the case with USCIS, yeah, you're seeking an immigration benefit, right? But what they're trying to say there, I guess, is that you created the whole case just to obtain the immigration benefit. And it's challenging at times, because usually, why would they say it to you, right? Well, usually they have some information that contradicts now story that you're presenting now. That's why. And it can be information that was left on your visa application if you came on a visa, maybe on other applications with USCIS, or maybe you provided some information during the credible fear testimony that is different from what you are claiming now, and hence you will receive a notice of intent to deny, a fee, or maybe straight denial. So those are the main problems with that, with the challenges, I'd say challenges in obtaining the status. But the status itself is great because if you get it, you're basically getting a green card, you will never be able to sponsor the parents, even if one parent was a good parent and another parent just whatever. you will never be able to sponsor those parents. I believe the question if you will be able to sponsor the siblings is an open question, meaning that some courts will say no, some courts will say yes. We will, I guess, see in the future. I also believe this area of law will be another area after which the government is going to go, right? The way after asylum. There was a litigation pending, and it's still pending in federal court in New York, where the judge just ordered that the kids in New York who are above 18 but under 21 do qualify for SIJ, even though the government, USCIS, federal government immigration, was saying that they were not. You can read more about special immigrant juvenile status on our website, www.shaltsova.com.